Good evening, everybody. Welcome to our event on getting the balance right, free speech and the right to protest in the current moment. Thank you all for coming here, and thank you also to those who are watching online. This event concerns issues that have been raised by the conflict in Gaza and the response to it in this country. As I think everyone is aware in this room and online, the protests have raised some very difficult questions. What are the limits of the freedom to protest? Is support for a belligerent in a war, and particularly a proscribed organization or a terrorist organization, is that unacceptably threatening to those who feel targeted by that group? We've grappled in the Free Speech Union with these questions, with much disagreement, and very much hope that the expert panel that we have here tonight will be able to shape our thinking on this matter, and also hopefully give everyone here and watching online food for thought as well. So if I can introduce the panel going from left to right. To my left is Jonathan Hall, KC, who is a barrister and was appointed as the UK's fourth independent reviewer of terrorism legislation in 2019. As independent reviewer, Jonathan has published so far 4 lengthy annual reports on terrorism legislation in the UK and 3 standalone reports on managing the release of terrorism offenders, terrorism in prisons, and the use of Schedule 7 powers against a French publisher in 2023. Next to Jonathan is Natasha Hausdorff. Natasha is a barrister and serves in a voluntary capacity as the legal director of UK Lawyers for Israel. Her practice focuses on criminal, regulatory, and international law, and she was a fellow in Columbia Law School in New York, and in 2016 clerked at the Israeli Supreme Court in Jerusalem for the late Chief Justice Miriam Nair. Moving on is Lord Ken MacDonald, KC. He is a former Director of Public Prosecutions and is one of the country's leading criminal, regulatory, and international lawyers. In 2007, Ken was knighted for services to the law, and in 2010 was appointed to the House of Lords, where he sits as a crossbench peer. Ken is chair of the Orwell Foundation. He's president of the Howard League for Penal Reform, and was warden of Wadham College, Oxford, from 2012 to 2021. And then finally, on the right is George Thomas. George, a barrister who enjoys a broad practice encompassing many of the more controversial areas in relation to human rights and discrimination. George has almost unrivaled expertise in the area of public order policing and has experience advising police forces and other organizations in relation to major public order events, and particularly the policing of protests. If I can add as well that George has very kindly stepped in at the last minute after Raj Chadha, who was down to speak, wasn't able to make it. So thank you very much, George, for stepping in like that. To start with some scene setting, if we can, from our expert panel, just to briefly set out the general area of law that we are talking about, and then perhaps we can move on to knottier questions of whether it needs to be changed. I think one sort of can very crudely break it down into sort of public order legislation and terror legislation. So, Ken, if I can just ask you just to briefly set the scene on the sorts of public order legislation that is relevant to the issue of protests at the moment.
The relevant public order legislation is relatively simple and straightforward. And I must say I've been quite surprised by some of the assertions by the police that they haven't witnessed offences taking place. That's a very different question about whether, on these demonstrations, that's a very different question as to whether they should intervene. I think those are 2 separate things that we need to keep them separate. The fact that you witness an offence doesn't necessarily mean you ought to intervene. It's never been the law in England that that evidence that an offence has been committed means that a prosecution must necessarily follow. So we should keep that in mind. But there are a number of offences I think may have been committed. And I think the easiest thing to do is to just read briefly some of the relevant passages from the Public Order Act 1986. The first deals with fear or provocation of violence. This is section 4. A person's guilty of an offence if he, it's all he in the Act, uses towards another person threatening, abusive or insulting words or behaviour, or distributes or displays to another person any writing, sign or visible representation which is threatening, abusive or insulting, with intent, this is important, with intent to cause that person to believe that immediate unlawful violence will be used against him or any other person, or to provoke the immediate use of unlawful violence by that person or another, etc., etc. So I guess in that case, the police argument might be that people are shouting abusive and threatening things, perhaps, or distributing or displaying abusive or threatening things, but the necessary intent is not there. I mean, that's a possible rationale for the advice that they're getting from the CPS, I suppose. Section 4A deals with intentional harassment, alarm or distress. A person is guilty of an offence if with intent to cause a person harassment, alarm or distress, he A, uses threatening, abusive or insulting words or behaviour or disorderly behaviour, or B, displays any writing, sign or other visible representation which is threatening, abusive or insulting, thereby causing that or another person harassment, alarm or distress. So someone has to witness the behaviour who is likely to be caused alarm or distress by it. Perhaps that's realistic in the context that we're considering of these large demonstrations. Perhaps it's not, I don't know. Section 5 deals with harassment, alarm or distress. A person is guilty of an offence if he uses threatening or abusive words or behaviour or disorderly behaviour, or displays any writing, sign or other visible representation which is threatening or abusive within the hearing or sight of a person likely to be caused harassment, alarm or distress thereby. So again, there has to be someone witnessing the abusive words or behaviour or disorderly behaviour, or witnessing the writing, sign or other visible representation which is threatening or abusive. Again, in the context of a large demonstration through the streets of London, it's quite possible to imagine situations in which somebody might fall into that category. Section 18, use of words or behaviour or display of written material. A person who uses threatening, abusive or insulting words or behaviour, or displays any written material which is threatening, abusive or insulting, is guilty of an offence if he intends thereby to stir up racial hatred, or having regard to all the circumstances, racial hatred is likely to be stirred up. Now, I think those are the most important public order offences. I mean, we could debate whether they're likely to have been met in some circumstances, in terms of some of the behaviour that we've seen on our television screens in recent weeks. We could debate whether some of those terms of the offences are made out or may have been made out to a sufficient extent that individuals could have been arrested and then referred to the CPS for charge. But I stress, and this is something we will probably get on to discuss later, the question is whether even if those conditions were met, it would have been a desirable or appropriate thing for the police to intervene in those circumstances to make arrests. And I don't think the resolution of that question is particularly easy. There are different models, certainly across Europe. I mean, the French model is to send in the CRS with truncheons and boots and knee pads and to beat the crap out of people and drag them out of the marches. That's a model which we could adopt. It's not a model which I would favour.
Thank you, Ken. And Jonathan, perhaps if you can just take us briefly through the terrorism legislation that may be relevant in this context.
Yes, to understand the terrorism legislation, you need to just have 4 concepts in mind. One is this very broad concept of terrorism, which catches Hamas violence on the 7th of October and Nelson Mandela. So political serious violence. That's the first thing to bear in mind. Very broad, quite useful, very broad concept of terrorism. Second thing is we have something called prescription. So a group, which is a terrorist group, can be banned. It's done by the Home Secretary and debated by Parliament. There's a limited number, quite a few, but it's a definite number of people, of groups. The third is to think about resources. So whenever you debate about creating new terrorism offences, think about the resources for police, MI5, and the impact on the public. If everyone becomes a terrorist, then MI5 and the police have got to commit a lot of resources. They can't do other things, go after Iran and hostile states and things like that. And also, these people end up being managed as terrorists. And also, the public probably gets alarmed because every day there's going to be a terrorism offence. So it's worth thinking about the use of terrorism in the context of the wider implications of having a lot of terrorists in the country. And finally, the question of remoteness. Ken has been talking about speech offences giving rise to threats or violence. I mean, that's ultimately what lies behind the Public Order Act, apart from race hatred. So apart from race hatred, it's immediate violence. Whereas terrorism, you don't have to have it so early on, so immediate. You can do things that stop people maybe causing someone else at some stage in the future to commit terrorism. So the harm is more remote, but because it's very serious, the law allows you to intervene earlier on, to prosecute, to arrest people way before a terrorist act has taken place. So with that introduction, there are 3 offences based around prescribed groups and 1 based around the definition of terrorism. For prescribed groups, it's an offence to profess to belong to a terrorist organisation like Hamas. It's an offence to invite support for or to make encouraging noises and hope that someone is encouraged to support a prescribed organisation. Very serious offences, long maximum sentences, serious impact in terms of managing you when you come out of prison, polygraphs, lots of visits by the police, etc. Heavy resource burden for the authorities. The third one is a strict liability summary-only offence that can be tried in the magistrate's court, and that is the one of displaying an article or a flag which gives reasonable grounds to suspect that you are a supporter of a prescribed organisation. So those are the 3 prescribed organisation offences. That's the one that's typically prosecuted with LTTE flags, PKK. Someone had a Hamas flag, they would be prosecuted under Section 13, one hopes. And then finally, the encouragement offence. If you encourage acts of terrorism, doesn't have to have anything to do with prescribed organisations. If you encourage, then you commit a really serious offence again with all the major consequences. Final thing I'll say about this is that the really serious ones have a mental element. So it would be a big deal, wouldn't it, if I now say, I support Hamas, if that suddenly means I'm now going to be committing a terrorism offence, I have to have some ulterior intention, don't I, to actually invite support, encourage terrorist acts, claim to be a member of Hamas, etc. So these really serious offences quite rightly have a mental element. The one that doesn't is the Section 13 flags offence, and that doesn't have have a mental element because it can be committed, but it's a very minor terrorism offence compared to the other ones.
Thank you very much, Ken and Jonathan. That was very useful. So after that framing of the issues and just reminding us of what the relevant law is here, I wonder if we can start digging a bit more into later on the adequacy of that law. But first, the question of whether it is being properly implemented by the police. And obviously Ken did point out to us there, as did Jonathan, the difficulties given resources. So Natasha, if I can turn to you. So given what we've been talking about with legislation that protects public order, seeks to restrict potentially imminent violence, and then also laws prohibiting support for terrorist groups, that's the general backdrop. What do you think are the particular sort of mischiefs here in relation to these protests? What are the potential threats that are posed by the protests that potentially the police should be restraining?
Well, the mischiefs strike me as the breaches of the law that has been set out so very clearly by my co-panelists. I have to, forgive me, apologise for my voice. I've clearly been speaking far too much of late and I've lost it. But I'm grateful if you'll bear with me. So that is a significant factor, the fact that offences, I believe we can say, have plainly been committed under both the public order legislation, but also when one considers the Terrorism Act 2000, in particular, Section 12(1)(a), the support being expressed, the qualification of recklessness that applies in that context. I think we've all seen examples, as we've heard on our television screens, of that law being broken and these offences being committed. The fact that that has not been properly dealt with in the first week after the 7th of October, and of course in the context of the atrocities that were committed on that occasion, has unfortunately led to a worsening of the mischief, a worsening of the situation, because it seems that far more people have been invited through that inaction to participate in similar law-breaking activity. And an additional level of mischief, I think in the context of discussing freedom of speech, freedom of expression, one has, of course, to recognise that there's always going to be a balance. And the police commissioner has been very clear that he has been seeking to strike that balance. The effect, however, of that inaction has meant that Campaign Against Anti-Semitism and their billboards, movable billboards of victims of the abduction, the hostages, were shut down. We had a Christian Action Against Anti-Semitism march that was essentially curtailed. So there's an additional mischief here that while these offences are entertained and the full force of the law is not being deployed, one has a serious curtailment for the freedom of expression of other groups. So far as arrest is concerned, the standard position, and I'll certainly be corrected if I'm wrong by my fellow panellists, is if there is reasonable suspicion that an offence has been committed, an arrest ought to take place. The question of intention, well, in the context, we can certainly discuss the policing. I fully appreciate the policing issues, and I'd love to come on to talk about that in more detail, because given that there are 35,000 operational officers in London, when one takes into account the Metropolitan Police, when one takes into account also the City Police, City of London Police, the fact that there were only 1,000 officers, I think, to be spared for policing 300,000 estimated marches. These are all obviously considerations of policing that certainly require scrutiny. I'm not saying that in every instance when there's reasonable suspicion, when these qualifications are taken into account, there has to be an arrest. But if we are considering intention in the context of some of these serious offences, then absent an arrest and an interview, it doesn't seem possible to me to properly assess that intention. And to understand from the individual committing what seems to be an offence, whether there's reasonable suspicion that an offence has been committed, to understand what their intention was. And we have seen previous examples of this. This is not new. The audience may recall the convoy in 2021 that drove through Jewish areas in London, calling to rape their daughters, activity that we unfortunately saw carried out on the 7th of October. The fact that the police were so slow to respond to the many calls they received from very frightened Jewish residents in those areas, so that when they actually got to the vehicles, the understanding that we have been given is that it was so late from the offence itself being committed that they couldn't be sure if the individuals who they found in the vehicles were indeed the same individuals caught on camera committing those offences. And again, no arrests seem to have taken place. One way of discovering whether or not they were indeed the same individuals, one might think, would be to interview them. Mm-hmm. And this is a consistent failure that unfortunately, since long before 2021, but we've seen examples of that, which does seem to have snowballed in the current circumstances. I just want to clarify and caveat what I've said with, I cannot for a moment start to criticise the individual officers on the street. It's clear, I think, when one looks at the footage, that they are outnumbered and that they are being put in increasingly dangerous positions and situations. But there is a failing there at a much higher level that has to be addressed for the sake of the officers and for the sake of the general public.
Thank you. So I'd like to come back in a bit to the question of when arrest is the appropriate tool, and Jonathan may have some thoughts on that. Now, I think as well the question of using arrest to sort of winkle out the intention of the suspect has got obvious issues or things to consider regarding resourcing. But thank you for that, and that'd be very interesting to touch on those. Ken, if I can move to you next. Now, there is a question which is exercising many people as to whether the police are being fair-handed. And it can very often be a very invidious matter when there's a perception that the police are playing favourites, as I think a former Home Secretary put it. So you've already intimated that it's a multifactorial question as to when the police should be acting and intervening. Do you think the police are being fair-handed in how they're approaching different groups?
Well, I think we probably all saw things that happened on the march that we felt ought to have generated a police intervention. I saw a photograph of a young woman standing next to the cenotaph holding a poster which had a graphic of Star of David being thrown into a bin and the words "keep the world clean," which is a kind of disgusting recollection of racial hygiene ideologies from the 1930s and earlier, actually, including in the UK. It's very difficult to believe there weren't police officers in the vicinity of the cenotaph, and I should have thought it quite likely that quite an unpleasant offence was being committed in respect of that sign, and I'm surprised the police didn't intervene. On the broader question, I think you've referenced in your notes, Bryn, an event when some campaigners wanted to drive a truck through London with the campaign for anti-Semitism, actually, with photographs of hostages on the side of the truck, and they were prevented from doing so. I completely fail to understand what the police think they were doing in preventing that. I think it was an outrageous way of limiting the right to free expression of those people. It was an entirely legitimate demonstration, it seems to me, that they intended to hold, and they should have been allowed to proceed with it. Yeah. They were claiming they were preventing a breach of the peace by doing that. That's a very weak claim, assertion, which is often made by the police when they want to do something without actually arresting somebody. They talk about breaches of the peace. I mean, demonstrations breach the peace. All sorts of things breach the peace. But I think that was a bad misjudgment. And I think on another occasion, there was a prayer walk, an anti-Semitism prayer walk, which the police, did they actually cancel, did they actually prevent that, or did they divert it in some way?
I'm not sure. Somebody here might know.
I think they advised them that there were credible threats of violence against the people participating in the prayer walk, and therefore they should cancel it. They didn't demand that they cancel it.
Well, I mean, I guess the police would just say they were giving sensible advice to those people. They might have thought that if there were threats against them, they could have provided some sort of protection so they could carry out their prayer walk. Otherwise, one is rather submitting to a heckler's veto. I mean, I think it's very difficult for the police on the ground when you're talking about assemblies of such large numbers of people. It's quite difficult to prescribe sitting here what they should and shouldn't do. I personally think that when there are gross exhibitions of incitements to racial hatred, the police probably ought to intervene, particularly if they are incitements that are proximate. I mean, the approach I took when I was DPP to offences of incitement to racial hatred was if the incitement was so gross that it appeared to be proximate to an event of violence, then we'd prosecute. If it wasn't, we wouldn't. Because we thought the Article 10 free speech balance tilted in the direction of Article 10, unless there was a approximate threat of violence. And I would take the same approach here if I was the police. And I'm not sure they always did that on this march. I've seen I've heard one or two grotesquely racist chants and genocidal chants and genocidal placards. And I think that in those circumstances, one might expect the police to intervene. But I don't think that it would be easy for the police to intervene on the basis of preventing a breach of the peace. And I think if 300,000 people want to march through the streets of London, the police have to be careful calibrate very carefully their response to such a demonstration. When I went on both of the anti-Iraq demonstrations, one was 1 million people and one was 750,000, and that is a very large number of people for relatively small numbers of the police to deal with. I personally would never have gone on one of these Palestinian marches. I'm strongly believe in the indispensability of the State of Israel, and I didn't like the tone of a lot of the placards and a lot of the chanting. But we live in a democracy in which free political speech has the highest protection under Article 10. the highest protection, and I believe in that as a principle. And I think people ought to be able to express political views that I disagree with.
Well, thank you, Ken. If you can hold that thought, because I think that's something we have to return to. George, apologies for taking some time to get to you. If I can ask, there's a perception among some that some of the mischiefs that Natasha has told about seem to be sort of falling through gaps in the law. So, for instance, Ken talked about the importance of proximity. But that's something that's often lacking, given that we consume so much through news content or online content. It's possible, one could imagine, for a British Jew to feel very threatened by what they're seeing remotely in a non-proximate way. So, I mean, that strikes me as one example of perhaps a gap, a mischief falling through a gap in the law. But if you've got any thoughts on sort of what is falling through the gaps, and also the importance to you of being in the sight and sound of threatening, abusive, or insulting words or behaviour.
The first point we need to bear in mind is we need to be very careful of reporting anecdotally what we understand to have happened in a situation. For example, in relation to the convoy in North London in 2021, it's not correct to say nobody was charged. People were arrested on the day and they were charged. Natasha is right to say that because they weren't, if you like, caught red-handed, the prosecution was subsequently terminated because they couldn't prove the people they'd arrested were the people who'd been doing the chanting. And it may be that the police response was slow, and of course, responding to unexpected events is a policing challenge in itself. Similarly, in relation to the video lorries that were stopped, the matrix sign lorries that were stopped in October, they weren't stopped because the police objected to the content of what was being shown on the sides of the lorries. They were stopped because there was a concern that the location where they were and the reaction of the crowds at that very location was likely to lead to a breach of the peace.
Where were they?
They were in central London at the time. They were next to a pro-Palestine protest. And so I'm not saying it was necessarily the right decision. I wasn't involved in that decision at all. But you can see how these policing decisions can be very difficult to second guess.
The moment
after the event.
they were stopped, they were in Parliament Square, and that protest, as far as one can see from the videos, was still at Trafalgar Square. So there was some distance between. But as you say,
there had been, as I understand it, again, we're all sort of none of us directly involved. There had been expressions of hostility towards the vehicles already by the time they were stopped, and so we need to bear that in mind. Another thing that we also need to bear in mind from the beginning, and Ken's just touched on it now, is the role that Article 10 plays, because Section 5 of the Public Order Act, the threatening behaviour, the abusive and behaviour likely to cause harassment, alarm, distress, has within it a specific defence that the conduct is reasonable. And exercising your Article 10 rights can constitute reasonable conduct under Section 5. And the courts have repeatedly said that expressing your views on political matters are to be afforded the highest protection. And so it can present the police with quite a difficult exercise. They are doing, somebody is using words, using language which, were they not exercising Article 10 rights, might plainly be an offence. Do we arrest now and let them prove their defence at court, or do we let them have their protest and decide after the event whether they should be arrested for what's gone on? That is something I think we all know that that's an approach the Met Police have tried to take, particularly faced with, as Ken said, what do you do? Do you start arresting people when there are 300,000 people on the streets? That is a very difficult operational decision. It can result in, of course, angry responses from the crowds. That can rapidly lead to a relatively calm, if somewhat offensive, protest, becoming a less calm protest. And that is something, obviously, that we all need to avoid. And so are offences falling through the gaps? They probably are on occasion. Are they falling through gaps because the police are taking entirely the wrong approach? Or are they falling through the gaps because the police are trying to take a nuanced approach, trying to balance rights and not always getting it right? Well, I think views on that will vary and perhaps very legitimately. The sight and sound point is extremely important because Section 5 doesn't really allow for somebody to be offended by what they see on television or read on social media.
That's correct.
But what Ken has said about Section 18 certainly does provide for that. So you can, if you incite racial hatred at the scene and it's then reported on social media afterwards, that can, of course, raise the spectre of racial hatred and certainly will raise perhaps the obligation on the police to intervene.
Indeed, the police said they were looking for this young woman who had been holding the placard that I referred to.
Yeah. So that's some of the nuance behind some of the offences we've been discussing.
Can I just add?
Sorry, Ken, I do want to come back to Jonathan, and then can I come back to you?
Yeah, I was going to deal with this point about arrest. I mean, Natasha, I think you're right that there were some circumstances where you would have hoped the police would investigate. So I think the use of jihad straight after the 7th of October, you might have said, well, the police couldn't really investigate that without carrying out an arrest. But I think it's worth thinking from a free speech perspective about the risk of the police having that sort of, what do you mean by that approach to life? Because frankly, any words that we use could be used to encourage terrorism. There's a famous example of a BBC 3 documentary called Three Girls, which inspired the man who carried out a killing of a Muslim worshipper in 2017. So I think we've got to be careful about the idea that the police should be checking what we do. The other point to make on this is it would be much easier if the police had clear rules. I think what they really want is not to be able to arrest, find that the person was just an idiot or drunk and didn't understand what they were saying. I'm afraid there's quite a lot of that, I suspect, in these marches. They don't really think about what they're doing. So what they like is clear rules. And one of the things I tried to do in the paper I published today was to work out, could you create effectively really clear rules? Could you arrest for certain phrases, for example? Well, that would just involve ridicule, wouldn't it? Because they'd very quickly find another alternative way of saying the same thing and go, there you go, it's not in the law. If you said you can't ever express support for Hamas, well, what if I want to say I'm very pleased that Hamas is freeing the hostages? Well, that would, surely I'm allowed to do that. Should you say, well, you can only express support for terrorism within the last, so you can't support terrorism within the last 20 years? Well, that would rule out 9/11. When do you set the threshold? Do you go back to the 7th century? If I said, well, it's an offence to support any attack by a terrorist organisation, which is prescribed, well, I might be quite pleased if the PKK carried out an attack on Islamic State in Syria and Iraq. And is it an offence to say that? So it's really hard to construct a rule that sort of says, this is the clear thing that you should not be allowed to do, and if this happens, the police should arrest. I think that's why it's so hard.
Thank you, Jonathan. I'm struggling to think of a 7th century terrorist movement.
Attack Khyber.
Yeah. Oh, I see. Yeah. Sorry. Okay. I was thinking of the People's Front of Judea, but it's not that. So, Ken,
I just wanted to add something to what George has said. It's not so many years ago, I think only about 6 years ago, that Parliament actually removed the word insulting from the rubric of another offence under the Public Order Act on the basis that insulting other people should not be an offence. So the particular section was left with the definition abusive or threatening. So there has been a trend in recent years to weigh Article 10 more heavily in the balance than we did previously, and of course before the Human Rights Act, since the Human Rights Act even more so. And I think people have to take a position on whether they think that's a good thing or a bad thing. If it's a good thing, as I think it is, it does mean that the police are in the position of making more and more difficult and more sensitive decisions in these sorts of contexts, because Article 10 has become a more important aspect of the way free expression, a more important aspect of the way that we think about these things. And I think that's a good thing. I'm very conscious in saying that the whole tenor of large parts of these demonstrations has been incredibly threatening and worrying for particular communities in this country. And that's not a negligible thing at all. It's not a negligible thing. Which is why I think where there are clear instances where the law appears to have been broken, I don't just mean disorderly conduct. There's bound to be some disorderly conduct in demonstrations, but where there are clear examples of incitement to hatred, they really ought to be. Those people ought to be arrested and they ought to be prosecuted. And if that means the risk of some disorder as people have their banners seized and they are removed from demonstrations, then so be it. There has to be some enforcement of law when the law is broken in serious and meaningful ways. I think the problem is that a lot of the offending that may be taking place in literal terms under the Public Order Act is not terribly serious offending. And in those circumstances, the risk of creating disorder outweighs the benefit in making arrests. But I think there have been instances where the benefit in making an arrest would outweigh that risk. And I don't think we've been seeing that happening. So I think there have been some mistakes made. I mean, I completely appreciate how difficult it is for the police on the ground.
I'd like us to move on, but Natasha, I will come to you first if there's something you'd like to add. I mean, just to sort of round that off, certainly it's our position that the police need considerably more training on freedom of speech. They tend to be quite well versed in the need to facilitate the right to protest under Article 11.
I'm doing my best.
Okay. So, we'll talk afterwards. But what I'd like to talk about now is perhaps the sort of knottier question of where should we draw the lines, or how should we strike the balance between the competing rights. Now, Ken, you've brought up the very high protection for political speech under Article 10 of the Convention, and indeed under the English common law. I think there is an interesting question as to the weight that we should give to these protests, and perhaps I'll come back to you, Ken, if I can, if there's any qualification you'd like to make to that. But Natasha, I mean, if I can turn to you for the sort of countervailing question, which is what weight should we give to the right to be free from threat? I think we all are very aware of the very real feeling of fear among many British Jews and its impact on their basic liberty to identify themselves and to pursue their religion. So what weight do you think we should give in the balance to that?
And how we have seen in not so recent memory and in more recent memory those threats manifest themselves. But I think it's extremely difficult to talk about these issues in a general sense or in a blanket sense. And this is obviously a problematic aspect of trying to deal with these issues in the context of this panel. Context is everything. And that applies to how one addresses those threats, but it also applies to how one addresses the words or the actions that constitute that balancing act against those Article 10 rights that we've heard about. And this is, I think, somewhere where we've consistently been failing. The Khyber al-Yahud reference to a 7th century massacre probably wouldn't mean very much to many in this audience, certainly wouldn't mean very much to friends of mine from the Shires, but to the audience that these slogans, these genocidal chants were spoken to in the context of many of these marches, the reference is clear. And the threats associated with that are clear. And we also heard reference to the way that the police had approached the term jihad. This tweet that we had adopting a dictionary definition of jihad is entirely out of keeping with the approach of the legislation, in particular the Public Order Act provisions that we've addressed. That is all about context. That is all about audience. And for the police to tweet in advance of a march and give a carte blanche, say, for the use of that term absent any of that context is really quite troubling. There is a case that I had been looking at from the Rwanda tribunal that dealt with incitement to genocide, which I thought was pretty instructive in terms of taking into account context, a judgment called Akayesu, where Akayesu himself described the Tutsis as the sole enemy. And that was sufficient to be considered direct incitement to genocide. His co-defendant, Nikagaka, was convicted for thanking a mob for their good work because in the context of the words which he was speaking, that good work was understood to be the killing. And that approach, that context analysis, that audience analysis, is not undertaken when one sees those clear lines, as it were, allowing what plainly seem to be offences to take place before the event. It prevents that proper analysis from being taken afterwards. And it's extremely concerning in the context of the question that you've raised, which is the threat that certain communities very much feel. Added to that, the Community Security Trust statistics on anti-Semitism in the aftermath of the 7th of October indicate that anti-Semitic incidents are up over 500%. So clearly there is an impact to these words and these actions. And when one considers also calls on social media that after the protest in central London, people should go to Jewish areas like Golders Green in order to make good the slogans, the comments, the chants, then that is also, of course, of grave concern. If a different approach had been taken immediately after the atrocities of the 7th of October, would we have seen 300,000 people following in the wake of those original offences? I'm not so sure we would have. And so I think there are really serious questions to answer as to the initial approach, because none of this was a surprise. None of this was expected. I referenced the previous events in 2021 in the context of another military operation in Gaza with respect to Hamas. Any member of the Jewish community would have been able to tell you what was coming after that Saturday, the 7th of October. And the fact that a blind eye, it seems to many people, was turned to these offences have plainly led to a broadening of the criminal activity, I think, that we've seen on the streets of the United Kingdom. In terms of the approach of police, I would just highlight a difference that I have witnessed with respect to, for example, Manchester police. Of course, it's up to each individual police force to determine how best to approach matters like this, but there is a stark contrast between approaches that have been taken by the Manchester police in previous years to very similar disruption, public disorder on the streets, and what we have seen recently from the Met.
Thank you very much, Natasha. I mean, certainly many people were very disappointed when the Met police pointing out that, jihad has the innocuous meaning of struggle or Kampf in German. Now, I was going to say, Natasha, I mean, your comments did line up quite nicely my next comment to Jonathan, which is regarding whether we can draw some quite specific lines regarding things that we could always identify as provocative or unacceptably threatening. Now, I know there's a danger that whenever you ask a lawyer this question, they'll say, well, it all comes down to context and manner, and indeed it does. But there has been some quite urgent sort of questions asked, haven't there, Jonathan, about particular hot-button things, hot-button chants, placard signs. Do you think the law could do that, could draw specific lines, just as the Public Order Act did in 1936, saying no marching in uniforms?
Well, I always try to think practically. Think about the harm that's caused, and the harm that I think none of us can really work out how to deal with is that general fear that Jews have about going to central London, a sense of being excluded from the streets of the capital. I think that's the really wicked problem here. If you have an example of some woman with Israelis in the bin cleansing and whatever, or someone going to Golders Green, I think it's fairly clear we could identify, or one would hope one could identify, an offence. But the really difficult one is that fear thing. And that's one I don't candidly have an answer to, because when I think about it in different contexts, it just doesn't work. So let's imagine I'm a Jew, I'm worried about going in, what might these people do? It's a horrible environment. But if you play that into another sort of context, into the whole transgender issue, for example, we know that people will say, it's a horrible atmosphere for me as someone who's transgender to go to to have a gender critical film being shown in university. So I'm really worried about this sort of subjective veto that you might have. And the same is true if you have this thing, I think you mentioned in your notes, the idea of sort of cumulative harm. So you might say, well, one demo, that's enough. Okay, you might not go to London, in the central London if you're Jewish, but then week after week after week, that cumulative effect. But again, that cumulative effect seems to me to go back to that sort of subjective feeling. And I just also am worried about the fact that the police, although the police are excellent, there are lots of them, and there are many police forces. And I mean, the Chief Constable of Berkshire, if he has this power to ban marches, or will we trust every Chief Constable up and down the land? I think you've got to think about the power that you're conferring to lots of different individuals, some of whom will be excellent and some of whom maybe less so. So I think that's the really difficult one. I will say this, and this may be controversial, I may be in trouble for saying this, I don't know, but is it possible that actually Jewish people can go more in than they think they can? Would be my question. I mean, I ask myself that question. Is it possible that the police could take a role which effectively accommodates more citizens? So the reason I say this is because when I did this review of prisons, I noticed that the Islamist prisoners like to dominate the space. So they would say to prisoners in the shower, you've got to wear bathing trunks, or you can't cook bacon. And really it was a sort of takeover of the territory. And that fear, I think, is that this, to some extent, where there are some Islamist bad actors, there's an element of takeover of the space. And I sort of would like to think that the police could facilitate other people to go in, so Jewish people would feel safe to go in on the days of the marches. And that might be a better way of dealing with the phenomenon than banning them altogether because of the wider implications.
I mean, there's an interesting question, isn't there, that if Jewish groups put themselves in sight and sound of some of these events, that there'll also be more probability of an offence being made out.
I mean, that is
I'm not suggesting you're proposing that.
That is right.
Yeah, thank you. I should say, I mean, I believe the Chief Constable of Berkshire is very professional. I don't want to defame anyone.
I said Berkshire, I was thinking of Trollope.
Oh, Berkshire, sorry, yes.
Barchester Chronicles.
Thank you.
No, I wouldn't say that.
Clearly went over my head, too literary, I'm afraid. Now, George, if I can move to you now.
Yes.
There obviously is a danger that some of these provisions, particularly Section 12, could they potentially criminalise people who are simply crass or aspirational? Someone who's trying to be provocative or to strike a posture saying that they support terrorism, or perhaps sometimes are they merely wannabes or Walter Mitty characters? So how do we make sure the law, and particularly these laws, don't capture things that are merely injudicious or unwise?
Well, I think in relation to Sections 12 and Sections 13 of the Terrorism Act 2006, I'm afraid to say that Walter Mitty doesn't have much of a defence
Okay.
because you could commit those acts recklessly. And so if Walter Mitty misguidedly thinks that it would be a cool idea to put yourself out as a bit of a supporter of terrorism to impress the ladies or something, I'm afraid he may find that the provisions of Section 12 or 13 come crashing on him. It may be a question for sentence, of course, but people do need to be very careful about professing support for terrorism unless they really mean it, and of course perhaps even more careful if they do mean it. But can I come back to this question of cumulative effect and the impact on the Jewish community in central London? There is absolutely no doubt that there has been a cumulative building of a sense of intimidation by the Jewish communities in central London, and one could look, for example, at the first march that took place, and say, well, would it be reasonable to impose conditions on that march, because it might lead to Jewish communities who aren't perhaps necessarily living in central London, although they're entitled to come to central London, of course. Where is the balance there? But actually, unfortunately, what's happened with Section 12 of the Public Order Act is it has become incredibly complex. It's very, very difficult to understand what it means, let alone to apply.
Could you just give us a brief explanation of Section 12 and Assembly?
Section 12 is the section that gives the police power to impose conditions on processions. For these purposes, mainly to prevent serious disruption to the life of the community. What serious disruption can now mean has got lots of extra additions. It's very difficult to work it out. For example, very quickly, there are two concepts that the police are now to take account of: relevant disruption and relevant cumulative disruption. Those mean different things, although they are both cumulative. Okay, getting confused yet? It's really hard, but fundamentally what it means, and I think I applaud the spirit behind this, is that when one has a situation as is currently developing in central London, with successive Saturdays, and there is a sense now in some areas of the Jewish communities that there are areas of London that are no-go areas on a Saturday afternoon. That isn't because of the first march, necessarily. It's because of the cumulative effect of these marches. And that, therefore, the police potentially now have a basis to act which perhaps they wouldn't have had when the first couple of marches took place. And I think it's important, and it may be, I don't know, it may be that the Met Police will now start to say, because the cumulative impact on the Jewish community is no longer tolerable.
What sort of conditions would you put?
Well,
it's very interesting to know in practice what could be done.
Location.
Well, timing is important. Timing and location is important. Where are the central London synagogues? What time do those synagogues on a Saturday finish and allow people to go to the synagogue and leave without the feeling of being intimidated as they're leaving to go home afterwards? I think those are probably the main areas. We need to look, I think, the Met Police need to look at chanting, not just jihad, which I think, frankly, it's fatuous to suggest that if you're chanting jihad in the context of military action on both sides, that you're talking about an internal struggle. It obviously isn't in that context. But there are other chants. There's the From the River to the Sea chant, which is very controversial and has been dealt with in different countries in Western Europe in different ways. One needs to look at whether the cumulative effect of things, which might be okay once, are now requiring action to be taken because of the effect they're having on the Jewish community by reason of their repetition.
Thank you very much, George. Now, I was going to sort of come to close things off, unless anyone's got anything they particularly want to add following that discussion. So the final question that I'd like to pose each panel member in turn is this. First, it's a two-parter. Does the law need to change, either in favour of the protesters, allowing greater freedom of protest, or against them, restricting some of the conduct that we've seen? That's the first question. Secondly, what change in circumstances might change the balance? For instance, an outbreak of war, a particular atrocity on domestic soil, or perhaps some pressing need for political expression, depending on what the panel members' answer is. So I hope that's not too complicated a question. And if I can go sort of in order left to right. So, Jonathan, first, does the law need to change, and what circumstances might persuade you otherwise?
Well, I don't think the terrorism law needs to change for the reasons I've given. I don't like the idea of for or against protesters. I'd rather say for or against particular conduct. The thing that I would hope that would get through is that if you look at Section 17 of the Public Order Act, which is the offence which gives you the definition of racial hatred for the purpose of stirring up racial hatred, is that it includes citizenship. So if you stir up racial hatred against Israelis or Zionists, then that counts. You don't have to stir up racial hatred against Jews. So I would just hope that the law is used to its maximal effect, because the stirring up racial hatred is the really useful one. It doesn't depend upon the presence of people who are going to be terrified. It's enough to wind your fellows up. So I don't think the law needs to be changed at the moment. In terms of the balance, if there was a terrorist attack, and let's hope there wasn't, then the use of the word jihad would become even more obviously culpable and likely to amount to encouragement. So I think that with terrorism, if there was actually attacks going on, use of those sorts of words would simply mean that it's more likely you commit the existing offences.
Just very quickly, Jonathan, in terms of the Section 17 offence, do you think there's any room to define in statute what stirring up means? It's very strange that you have this metaphorical phrase not defined, and as far as I know, the courts haven't defined it.
I agree. It's like something from Tolkien, and I tried to find out what stirring up meant, and I couldn't. There's no case law on it. It's not in the legal textbooks. I think I'd probably say, well, that's a rather good thing, because it means that one can be, duly creative with the law and apply it in appropriate circumstances. I mean, it'd be interesting to hear from Ken when we get to him. I think you were saying you wouldn't have prosecuted stirring up unless there was proximate violence. But with
I was talking about incitement to racial hatred.
Incitement to racial hatred. Forgive me. So for the woman with the star of David in the bin, that would be a stirring up.
Yeah.
Sorry.
Interesting. Thank you, Jonathan. Natasha, if I can put the same question to you, does the law need to change either way? And then what change in circumstances might persuade you otherwise?
Well, you asked about whether the position would change if there were an atrocity. There was an atrocity. There were thousands of atrocities on the 7th of October. And these marches began before there was any Israeli response. So I'm slightly surprised by the question, but when we...
Forgive me, I meant on UK soil, but I do understand what you're saying.
Of course, but when we consider... I hope our memories are not so short. When we consider victory to the Intifada, which it seems has even been tweeted by members of my profession, I think it's very important that we remember what the Intifada looked like on the 7th of July, what it looked like in the Manchester Arena bombings, what it looked like in the London Bridge attacks. That distinction and differentiation is something that I'm finding increasingly hard to understand. Similarly, distinctions between Jews and Zionists, Jews and Israel. I think certainly the last months and a half ought to have disabused us of any notion that one can make any sensible distinction where one is considering the sort of hate that we have seen on our streets. So the context is absolutely critical. And while I entirely take the build-up that we have seen in relation to certain of the public order offences, in relation to the Terrorism Act offences, the context of encouraging support for Hamas in the immediate aftermath of the 7th of October is also a very important one to consider. In terms of new legislation, well, there have been repeated fervent calls for the full prescription of the IRGC. That is particularly significant in the context of these hate marches where there are certainly reports that many of the groups organising them have links with the Iranian Revolutionary Guard Corps or organisations affiliated with them. The Home Office has consistently been, it appears, behind that call for prescription, but there seems increasingly difficulty from the Foreign Office, considering that we have had Iranian terror plots foiled on UK soil with the assistance of the Israeli security authorities. The case against full prescription for the IRGC is incredibly difficult to understand.
We've never prescribed a state. That's the key issue.
Well, this is prescribed as a terrorist group elsewhere. And one, I think, we can have a whole separate panel about whether or not one considers the IRGC to be inextricably linked from Iran.
Sorry, can I just ask, so prescription would be ministerial action, is that correct? It wouldn't need to be, you wouldn't need new legislation to proscribe another group, is that correct?
You would simply add it to the schedule.
Can I ask Natasha, just on legislation, where you stand, does there need to be change?
So I would have thought that the legislation is clear, but unfortunately it's not being enforced. And so increasingly I'm sympathetic to the claims that we have heard that there needs to be new legislation in order to counteract the claims from the Metropolitan Police Commissioner that the legislation is simply not sufficient. My primary position is that, and I think it's become clear from the expert analysis we've had on this panel, my primary position is the legislation is clear. It's sufficient in the context of what we have seen, even in the context of from the river to the sea. Again, it needs to be understood after the 7th of October attacks, when it was first being uttered on the streets of the United Kingdom. It appears in the Hamas Charter, and it has been repeated in the context of calls for the 7th of October to happen over and over again. I'm not saying that every instance of it mandates that an offence has been committed, but the analysis of context and audience is critical. If the current legislation is not being properly enforced, then one approach, one mechanism for remedying that would be further legislation. But I have great sympathy for Jonathan's position that what is already on the statute books is sufficient and ought to be properly enforced.
Thank you very much, Natasha. Ken, can I put the same question to you?
My view is that we've got more than enough terrorism legislation, more than enough public order legislation. In fact, I think we've probably got too much of both. And so I certainly don't think we need any more legislation. I think it'd be a disaster if the politicians started grubbing around trying to work out more ways in which to restrict people from expressing their views, and more ways in which to have concepts of terrorism intrude into the normal criminal law. So I think that'd be highly undesirable, and I'm against it. I do agree the problem here is one of application of the law to the facts on the ground, and I think it's particularly difficult because of the context, which is hundreds of thousands of people. And the fact of the matter is there are events taking place in Israel and Gaza which are hugely tragic, hugely violent, hugely criminal, hugely distressing, and people feel very strongly about it. And people are going to express their views. People are going to express their views forcefully. Hundreds of thousands of people are going to come out to march about it. Some of them, no doubt, encouraged by the Home Secretary's stance before the third demonstration, which leapt from 100,000 to 300,000, quite predictably, I thought. And that's going to present the police with all sorts of difficulties. But there are occasions, I think, when we've all seen what we believe ought to be criminal offences being committed and nothing done about them. I mean, I've watched the video of those young men outside the Egyptian embassy chanting jihad now. They weren't talking about personal spiritual struggle. They were calling for violence and violence around the world. They were calling for international jihad, which no doubt includes London. They should have been arrested and they should have been prosecuted. When I was DPP, we had a group of men marching down the street with banners shouting, "Behead those who insult the Prophet." And I was advised not to do this by Treasury Counsel, but we did prosecute them for incitement to murder. They were convicted at the Old Bailey and they all got 6 years. I mean, if you break the law in a gross and florid way, you have to be prosecuted. And we've all seen examples of that where the intervention, I think, hasn't been there. And I think that's partly because the police have been very, very sensitive to the possibility of serious disorder and have wanted to avoid it and perhaps haven't intervened where on occasion they should have. I think from the river to the sea is a really interesting example of the dilemma that we face and the police face. This is a chant, this is an expression which has been used traditionally during intifadas, and it means literally, we will push the Jews into the sea. We're going to push the Jews off the land of Israel and into the sea. There's no doubt that in that context it is genocidal. It also carries all sorts of horrible resonances of events that happened in Eastern Europe during the Second World War when Jews were pushed into marshes and left to drown. It's a horrible expression seen in that context. But it's not unlawful to call for a free Palestine. It's not unlawful to call for a single Palestinian state in which Jews and Palestinians live together. My neighbour's son went on these marches and I was asking him about what it was like, and he said, "I didn't see any trouble, I didn't hear any nasty chants." I said, "What about from the river to the sea?" He's a nice kid, this. He said, "What's wrong with that?" And I said, "Well, couldn't it be seen as genocidal?" He said, "Oh no, what we want is a state where Israelis, Jews and Palestinians live together in peace from the river to the sea." And I've no doubt at all this young man believed that. And that's the problem. If you're talking about arresting somebody and prosecuting them for saying something like that, there are just too many reasons why that prosecution is going to fail. And too many reasons why it's going to be an impossible prosecution. I'm speaking now as a former prosecutor. You're never going to prosecute someone for standing up saying, from the river to the sea. You're going to need something else. You're going to need some other chant, some anti-Semitic chant or some other banner that contextualizes it so it means what Hamas want it to mean. The trouble is that by no means everybody chanting from the river to the sea on a demonstration like that means what Hamas mean. And to disentangle that through the application of the criminal law is an almost impossible task. So I would always, in these situations, in favour of free expression. But where the law is, I mean, we were criticised a lot for prosecuting those young men for their banners. But when the law is broken in that way, you have to prosecute them and prosecute them hard. And I think that's part of regaining the confidence of people. I mean, it really is disgusting if Jewish British people feel they can't go into London on a Saturday afternoon. That is disgusting. And, you know, we have to create an environment in which that is not the case. But we're not going to do it by abolishing everyone else's right to free expression.
Thank you, Ken. George, if you can round us off, please, with the same question to you.
We seem to have a near unanimous view that the police probably don't need more powers or more offences. They need to enforce the offences that they already have. I agree that the police need to have a sophisticated understanding of the interaction between Section 5 of the Public Order Act and Article 10 of the Human Rights Act. And of course Article 9 of the ECH, I should say, because the rights of Jewish people on a Saturday afternoon to go to the synagogue are as important as someone's Article 10 rights to free expression. There's no hierarchy between those rights. But do we need more laws? No. I think Section 12 could be simplified. That's the little bee in my bonnet, as you may have already realised. What is unfashionable these days, particularly since Liz Truss failed to defend the judges several years ago when she was Lord Chancellor, is to look at the guidance that court decisions, appellate decisions have been giving on enforcement. And just for the lawyers here, I would point to three absolutely brilliant judgments. You've got the Supreme Court in Ziegler, you've got the Court of Appeal in Samidi, which was the Occupy London protest, and you've got a recent judgment of Mr Justice Chamberlain in the case of Hicks and DPP, concerning an anti-vaxxer on hospital premises. You read these judgments and they tell you how to enforce the law in relation to the Public Order Act and Articles 10 and 11. The police need to read them, understand them and apply them. And that's not a criticism of any particular police. I think that's what the law needs to do. The judges can help the police understand how to enforce these offences.
Thank you very much. Before we go to questions, I'd just like to give a round of applause and say thank you to our panel. Fantastic contributions. So I think we've got about just over 20 minutes for questions. I forgot your name. I'm so sorry. Can you introduce yourself?
Kiki.
Thank you.
Kiki Hausdorff. Police in both London and Manchester have taken down posters of Israeli children who have been abducted by Hamas. The posters are calling for them to be released, a call, I think, which we can all agree on. I think any person with an ounce of humanity would agree that they ought to be released. Police have taken them down, citing community tensions in an effort to avoid increasing community tensions. What is the legal basis for that? And is it an appropriate use of police powers? Because the implication has been a deepening of the mistrust, particularly by the Jewish community, of police, a feeling that they cannot be relied on to protect the Jewish community if they are taking down these posters. So I'd be interested to hear the panel's comments on that particular action by the police and whether they think it is justified or reasonable.
Anyone?
I've no idea what power they were purporting to exercise in doing that. I suppose general power to keep the peace, if that's what they thought. But I mean, it's very difficult for me to hear something like that without feeling disappointment, more like anger, actually, that the police should do that. I suppose there may conceivably be some contexts in which it might be appropriate for them to do it, but I'm really struggling to think of justification for the police removing the photograph of a kidnapped child, a child who's been kidnapped by terrorists from a wall in the United Kingdom, frankly.
Yeah, I agree. And I think that the police, thinking about rights of freedom of expression, I mean, this was an absolutely clear example of someone wanting to express themselves. And I sometimes think that the police, the authorities, need to take positive steps to support that right, as well as positive steps. I mean, this is why it's so hard, isn't it? But I mean, that was a really good example of someone having a really strong need and desire to express something which was utterly legitimate. And it seems to me that these shadowy people who were in the wings waiting to attack the van or whatever seem to hold some veto over free expression.
It's also, it feeds into this point about people feeling safe walking into central London. If Jewish people don't feel that the police are supporting them, that's half of the problem there, isn't it?
It's really difficult, and I think all of us would agree that tearing down posters calling for hostages to be released isn't something that should happen. My understanding is the Manchester officer who was seen doing that is being investigated for conduct matters. The situation in London, as I understand it, is slightly different. The posters were put up, I think, on the shutters of a shop operated by a Muslim individual who had himself made perhaps unwise or offensive comments about Jewish people. And so there was an extent to which there was a tit for tat, and there was a feeling that things were escalating.
I think we're talking about the van. I'm sorry. We want to talk about the van.
The van is also. I think the van is another example of a similar problem. Yeah, which is to what extent do and there's case law going back to the 18th century about the heckler's veto. To what extent do the police take action against the innocent person to prevent the mob from reacting in a certain way? And it is uncomfortable and distasteful when they do it. Sometimes it's necessary. I think we all agree it shouldn't happen unless it's absolutely necessary.
I suppose a problem here is that these events all seem to have the effect of suppressing Jewish speech rather than the non-Jewish speech, and that's problematic, isn't it? There are probably examples on the other side, but it's problematic if a lot of stories are circulating about Jewish speech being repressed.
If it's an accurate reflection, it's problematic. Yeah. If it's an inaccurate reflection, it's still equally problematic, but for different reasons.
Yeah, exactly.
Just on that last point, when one looks at the difference between some of the rallies of support for Israel that we have seen, which involves songs for peace, flags, and expressions of love and unity, in comparison with some of the aspects, not all, but some of the aspects of the marches that we've been discussing for the most part tonight, the overwhelming impression is that the law is being enforced where it is going to meet with least resistance. And so when there is the possibility of tensions, the source of those tensions is not being tackled. If it is coming from, a march where there are calls for genocide, because they may be many in number, and then the police may not have sufficient resources to deal with where these protests have now got to. But the soft targets, the posters and the vans are bearing the brunt of the clampdown. And in the case of Campaign Against Anti-Semitism, that rented those vans in the first instance, after the police videos went viral of those screens being shut down on Parliament Square, they found it entirely impossible to rent a van and were forced to purchase one in order to continue what they considered to be a very important information campaign of keeping the memory of these hostages in the public eye on the streets of London. So the impact of that clampdown by police has had a very palpable effect, which is probably not even known in general public discourse, on the ability of that campaign organisation to exercise its free expression.
Thank you, panel. Sorry, Kiki, do you have a very...
Just a very quick follow-up. The context of the London occasion, absolutely, it was in response to social media posts which called Israelis filthy animals and called for Hezbollah to get involved in the conflict. That's the context. That's the source of the community tension. And so what we're seeing is Jews being silenced when they are being attacked on social media. The community tension source is not being dealt with. It's the victims that are being dealt with.
Okay, thank you. Just before I take the next question, just a reminder that people watching at home can also pose a question. But John, can we go to you, please?
I don't think anyone's mentioned Suella Braverman so far tonight.
I did.
So I'd like to just say a few words in support of her, because didn't she hit the nail on the head where she said the problem is the police are playing favourites? And we all know this to be true, that the police are very soft on certain protesters who they don't like, and they're soft on protesters they do like, and rather hard on the protesters that they don't like. And Suella Braverman gave plenty of examples of that. We had a few in the meeting tonight. My favourite example is the man who walked down Bethnal Green and took pictures of all the Palestinian flags. And he said, "Oh, look at all the crap that's up here." And the next day, a van load of police officers turned up at his door and arrested him. I mean, all of these examples speak to one thing, which is that our police force has suffered the woke mind virus that has infected so many other of our institutions. And that means they cannot police objectively because they pick sides. And I think Suella's big crime was that she said the sorts of things that most people don't want to face up to.
Panel, could you maybe turn your microphones on if you fancy answering a question? That would be quite helpful to me. George, can I direct it at you if you're willing to field it?
The woke mindset in modern policing. Well, that is a big concern, which I understand a lot of people have. It's not for me to say definitively there is or is not a woke mindset in modern policing. I suspect you can find in all public organisations statements of opinion that would fall into the category of stupid or ill-informed to support the view that the police are woke, or to support the view that the police remain horrendously right-wing and reactionary. Did Suella Braverman have a point? Well, of course, one of the problems with many inflammatory statements, and I think her statement was inflammatory, is that there's a grain of truth in it. And there may be a grain of truth in the fact that the police have struggled, for example, to react immediately to the word jihad because of concerns that it might have it can have an innocent connotation. Are the police playing catch up? Well, perhaps they are, in terms of understanding precisely what is going on and the impact of some of these words if immediate action is not taken. And I think all of us can probably recognise that the inertia in response by the police in certain situations is unhelpful and is counterproductive. I don't think that's the same thing at all as saying that the police are unwilling to take action against one side or that they have taken sides. I do not think they have. I think some of the problems raised are more difficult to deal with operationally, and that can come across as taking sides. I can see that.
I'd like to get through more questions. Is anyone desperately wanting to give an answer to that? Or should we go to the next question? I think, George, you gave it a good answer. James.
I think Jonathan gave asked some very interesting questions about this concept of supporting terrorism and spoke well about the police, quite understandably, liking to have clear rules. And of course, we all know that the less clear the rules are, the more power is given to those who enforce them, and the more fundamentally dangerous that those rules are. There are, of course, until really very recently, when this offence of supporting terrorism was introduced, there was a very clear rule, which was that the thing that is criminal is inciting a criminal offence. Does the panel think that is perfectly sufficient and that it is wholly unsafe to allow a government to have the power to pass an offence about supporting terrorism in circumstances where that might include supporting the idea that a particular organisation ought not to be proscribed?
No, I disagree. Incitement was not enough, which is why they passed those provisions in the Terrorism Act 2000. Partly because the harm that you fear in the inviting to support a prescribed organisation is quite remote. If you were saying, if I'm inciting someone to commit murder, an immediate crime, then there's plenty of ways in which you could prosecute that. I remember you've got to qualify the support for a prescribed organisation. There's got to be a mental element, so you've got to subjectively be aware of the risk that by saying what you're saying, you're going to support someone, you're going to invite someone to support a prescribed organisation. What you're saying has got to be supportive of a prescribed organisation. So in your example, which is, I think that so-and-so should not be prescribed, I'm not inviting support for that organisation. And I think that Ken would probably say, as a DPP, there's no way on earth that you would begin to prosecute that because, no jury would. Sorry?
Too remote.
Too remote. There's no sort of terrorist element to it. And I mean, the point about discretion is, for terrorism, discretion is quite good actually, because there's a lot of conduct which could qualify as terrorism. As I gave the example of the Nelson Mandela being terrorism, just stop oil can qualify as terrorism quite easily. But actually what you do want to have is a card, and this is quite an unfashionable opinion, and many, a lot of academics would say, you need precision, you need to get rid of discretion. If you have too much discretion, you risk the state being overweening. But actually you want a cadre of highly trained people, MI5, counterterrorism police working together, exercising discretion really well.
Do you think we have that?
I'm not bidding for a sort of job from anyone. The answer is, I do actually. I spend a lot of time with them and I think they're really impressive.
Okay, thank you. Could we go Toby, then Alan, then Gareth, please?
The Free Speech Union, when the online safety bill was wending its way through Parliament, campaigned quite vigorously to remove a new offence that would have been created in the bill called the harmful communications offence, whereby if you communicated something that caused someone else or was likely to cause them serious distress, you could be, if you met various other tests, be imprisoned for up to 2 years. And I'm conscious that we were successful, it was stripped out of the bill, but I'm conscious now that some of the things that people in the Jewish community object to, that are being chanted, symbols, flags, on the protests every Saturday since October 7th, some of them might be prosecutable under that offence, and they could have been prosecuted had we not vigorously campaigned to have it removed. And I'm conscious of the argument you made, Jonathan, a good argument, I think, that if we say that the safety of a particular community needs to be taken into consideration, and in some cases we might need to, well, if you argue that we need to change the law to protect the safety of, say, the Jewish community, that law could then be invoked to prevent, say, Kathleen Stock speaking at the Oxford Union on the grounds that it might. But one of the reasons we object to these safetyist arguments and didn't like that harmful communications offence is because, as you say, it's often subjective. It grants a heckler's veto to activists who will claim emotional harm and feelings of unsafety. But in the case of the Jewish community, objecting to chants like Intifada from London to Gaza, they're not talking about their emotional safety. They're talking about their physical safety, which doesn't it make it a stronger argument? And isn't there a risk that if we don't do enough to safeguard the physical safety of the Jewish community, then Jews will start emigrating en masse to Israel, as they have done from other European countries where there hasn't been enough done to protect them from anti-Semitic offences and speech. So, weren't you a bit too casual in your dismissal of that argument and the analogy with the, I think, bogus claim by trans rights activists that people like Kathleen Stock make them feel unsafe?
I'll respond briefly to that. I think you've got to distinguish between two harms here. So, in the distress example, the harm is the emotional feeling that I have. I demand to be protected from that emotional feeling of unhappiness because of the words that you cause. That seems to me something that you wouldn't want to support. I'm not speaking for the Jewish community, but I can imagine being myself married to a Jewish woman and talking about it a lot. What you're really worried there, by way of the harm, is the harm that might ultimately be done to you. So the way of capturing, I think, that, or preventing that mischief, is to use the stirring up racial hatred. That's your real concern, isn't it? It's not I'm a Jew, I'm worried because I hear this stuff is making me feel sad. It's not nice to feel sad. What we're really worried about is that there is a creeping environment where people are off the hook and saying, let's do this to Jews, let's do this to Zionists. And what you're really fearing there is what someone might do as a result of being stirred up. So if you distinguish between the harms in that way, I think you can say that looking at the distress element is not really dealing with the harm that Jews are worrying about in that situation. It's how I'd answer that.
If I could ask a follow-up question, do we know if and obviously I don't expect you to betray any confidence, but do we know if the Attorney General might be minded to approve charges and prosecutions under the stirring up offences, given that there's a need, isn't there, for the Attorney General's consent?
Well, I mean, I would have thought that if there was evidence of those offences being committed, I don't think there's any way in which she'd be withholding her consent. Okay. There's no policy ground on which she'd withhold consent. In saying, I agree entirely with the way you've just characterised it. I think stirring up offence is the real key to this, and it's the one that ought to be deployed in the sort of examples that we've been talking about.
Thank you. So there were two more, Alan and Gareth. I hate to do this. Are there any women with questions? It can't all be men, for goodness sake. Alka, sorry, we'll then come to Alan and then Gareth.
Yeah, so one of our panelists said, I think eloquently, that we live in a democracy where free speech has the highest protection. And I wonder whether that's really true. And I'd like to raise precisely the question of the Terrorism Act, right? So let's grant that Hamas is a completely evil organization. I think so. I think everybody in this room thinks so. And let's agree that it should be illegal to send material support to Hamas, money, weapons, so on. But if someone writes on their Facebook page or on their Substack or in the newspaper, support for Hamas, what are they committing? They're committing a speech offense. They're not giving any material support to Hamas. They're simply expressing ideas. I thought that we learned from John Stuart Mill 150 years ago that we should not suppress expression of ideas. We should refute those ideas. Hamas is evil, and we should refute people who support Hamas. We shouldn't put them in jail.
Natasha, were you looking to answer?
We've discussed at some length the legislation, which I think squarely deals with the situation that you've raised at 12(1)(a) of the Terrorism Act 2000. But there is your question has prompted me to consider one significant mischief, which we have not addressed at all yet this evening, and it manifests itself in a couple of respects. What we saw on the 7th of October, 3,000 terrorists, not just Hamas, they included Palestinian Islamic Jihad, Popular Front for the Liberation of Palestine, Fatah, affiliates of the PLO, the Palestinian Authority in the West Bank, the so-called moderates. We saw 3,000 people who didn't just get up one morning and decide that it was a good day to slaughter Jews and commit those atrocities. We saw 3,000 people who had been subject to 30 years of brainwashing. And I think we ignore the impact of brainwashing, education, indoctrination at our peril. We saw the impact of it last month, but I think we need to be alive to the impact that support for terrorism, unchecked, even in our schools, has. I taught many, many years ago on a debating program at Bethnal Green Technology College, which became Bethnal Green Academy. And that was the school that the three girls famously fled London in order to join ISIS, were educated in. I actually wrote at the time in 2009 about my experiences teaching there while I was working at the Centre for Social Cohesion in London. And I wrote about my concern, about what I had seen in classes, about support for terrorism, and how the teachers were utterly unequipped and terrified to engage and intervene and counter that.
Can I ask you to sum up? Sorry,
yes,
we've
of
got
course.
a couple more questions.
So in the context of the question that you've posed, it is based on our ability to counter speech with speech. And that has plainly not been the case. And it is a great concern to me that education, that indoctrination, that I draw that parallel with what we saw after 30 years of much, much stronger indoctrination. Don't misunderstand me. But the lesson I think that needs to be learned is similar. And the reason that we have strong terrorist legislation for support that is voiced, reckless to the encouragement of support for those groups is an important part of the armoury in countering that.
Thank you, Natasha. I mean, I think there's a lot more that potentially could be said on Professor Sokol's question. I think it's probably one for drinks, which are waiting, by the way. So if we can have two crisp questions, one after the other from Elke, then Gareth.
Thank you, James. I'll try and be crisp. But the example just given, is it? I'm not a lawyer, but I'm asking you guys. Is there not a difference? I mean, you want to have free debate of all ideas, even offensive, horrible ones. But if an organisation is prescribed, then if you're supporting it, whether it's in the does the fact that it's in the press give it greater protection? Or I mean, to me, it seems like you're still supporting it, right, in a public sphere. I mean, you might want to say it in your home or if you have a private meeting, but if it's in the public sphere, is it not still support?
Okay, and then Gareth.
Thank you, Bryn. Yes, just like to raise, if I may, the issue of cumulative impact, I think you said, under section...
Cumulative disruption.
Cumulative disruption, which has an impact upon, in this case, our Jewish community. I raise a heretical thought in the context of a free speech union meeting here, which I love and adore this body. But is it not possible to find a solution which makes our Jewish community comfortable walking through the streets of central London on a Saturday afternoon? And I don't just mean walking past the synagogue or coming out of the synagogue. I mean, just being able to walk the streets of central London without a degree of fear on Saturday afternoons when these marches are taking place. Perhaps by using this concept. I'm a barrister practicing in planning and licensing and gambling, and we have similar concepts of cumulative impact and effect. And local authorities take action using discretions. They don't ban all planning, they don't ban all licensing or gambling, but they restrict. And I'm just wondering whether there's anything in section 12 which may assist us here, perhaps in terms of restricting some of these marches. And I know it's an heretical thing to suggest here, but my primary concern is the effect upon our great Jewish community. As Toby said earlier, we don't want them leaving in droves to go to Israel. We want them here and we value them here. So is there something under section 12, I hate to raise the dreaded word guidance, which might assist us in this in terms of perhaps limiting these marches ongoing, not cutting them off forever, but
so if
calming them down.
If we can have a sort of a minute-long answer to each, if that's all right. So we can take Alka's question first about the significance of the process being reported in the press. I think that was your question, and whether that confers extra protection. If anyone wants to take that, I don't know, Ken, if that's one.
I don't want to do that. The only offence of support, where it doesn't matter what you intend, is the one where you're displaying an article. So you can't commit it just by words, and it's quite important that you can't commit by words. Otherwise, you'd be committing a terrorist offence all the time. Yeah. In answer to Professor Sokol, as in, are you the Sokol hoax? Oh, my word. I mean, I'm going to have to come and talk to you afterwards. I mean, wow. Okay.
What I said was not a hoax now.
No. But I mean, you know, I think I spend a lot of time looking at online stuff. I think that if you take what I think you're hinting at, which is that you should never really have an offence based on speech, if you're really saying that in the absolutist sense.
That's what I'm saying, except for incitement to imminent violence.
Yeah. I mean, I think you've just got to spend a bit more time on 4chan and 8chan and these terrible online forums that encourage particularly children to encompass and carry out the worst acts. Not based on immediacy. They circulate a video of the Christchurch mosque. They have the gamify where you kill black people, and none of it is immediate. They're not saying go now and take a knife, but I'm afraid that's what these children end up doing. So I think I would say that there's some speech is sufficient conduct to found a criminal offence.
So you're talking specifically about speech addressed to children, or are you considering that adults should be treated like children?
I would also include to adults, and I'll stop because I know.
Sorry, this is one for drinks. I'm afraid, because
This over drinks.
We are running over time. So, George, can I pass you the section 12?
Yeah, absolutely.
And just another minute-long answer. A very long minute that Jonathan took there, but just a minute.
This perhaps ties both of those points together. You've got the frog in the pot and the gradually increasing temperature. And until very recently, internet memes were once you mention the Nazis, you've lost the argument. But of course, the Article 10 of the ECHR was itself drafted in the wake of the horrendous for World War II. We've had the biggest killing of Jewish people in a single day since the Holocaust. And we are seeing a rise in anti-Semitism. And you look back in the 1930s in Germany and say, at what point did it become okay to start to say these sorts of things about Jewish people? Article 10 says the freedom of speech carries with it duties and responsibilities, and it may be subject to such formalities, conditions and restrictions as are necessary for the protection of the rights of others. Now, it's not an absolute right. And if it's necessary to restrict my speech to protect the rights of others, it should be restricted. And that feeds into the cumulative effect under Section 12, because I think that's a good development in Section 12, because it means that in balancing the rights of the Jewish community against the rights of the protesters, as the protests become more frequent, as they become larger, every Saturday there comes a point which you've got to say you balance the rights of the Jewish community, the rights of the protesters, and now perhaps there are restrictions which are justified under Article 10.2 that would not have been justified perhaps if this was a one-off protest.
We're going to have a very slender addition from Ken, and then
how many weeks do we need, though, George?
I'm slightly anxious about that formulation. I mean, it's obviously right that the European rights, free speech rights in Europe under the Convention are much more heavily subscribed than they are, for example, in the United States under the First Amendment. But I think a formulation that says that if my right to free speech impacts on someone else's rights, then it appropriately uses the curtailment of my free speech rights is far too broad a formulation. I would be looking for a very, very significant impact, a really significant impact on someone else's rights before I would curtail a free speech right, for all the reasons that we can see in the transgender debates and elsewhere. It's so easy to set up a breach of rights following from someone else's exercise of their free expression rights, and I think we have to be very, very cautious about that.
Thank you, Ken. Jan, do you want to read a question from those watching online?
I feel like I should represent the online audience to an extent. So I will just take a moment just to say some of the points are largely comments about the double standards in policing. A direct question about has the CPS failed to support the police in taking action against protesters who stepped out of line. Another direct question about what's the reality of the law when it comes to war memorials and clambering on them. And then another interesting point, which is about somebody making the point, actually, it's not just Jews who have found the protests intimidating, but people who disagree with them. So how do we deal with that? And then conversely, somebody who was on the protests and said, well, there are legitimate reasons to be on those protests. He said it was the body count in Gaza that he wished to express concern about. And he says he actually had a placard on that protest which said, "Down with Hamas." I'm trying to find what he said is on the placard. "Down with Hamas, free the hostages, 710, never again." So I'd be interested to know, I didn't see him in the press, but I'd be interested to know what the response was to him on that protest, because I know Peter Tatchell didn't get very far with his placard with a similar sentiment. And finally, just somebody making the point that anti-Semitism seems to be much more a cultural rather than a legal problem that requires a much bigger response. And that's it. That fairly represents what's in the Q&A, although some are missing.
Well, thank you, Jan, and thank you also to all of those watching online, to everyone that came here tonight, and especially to our panel. If we can give them another round of applause, please, for their contributions.